this conference was Peter's idea. So really, I am no more than a provider of accommodation. And it was Peter and Max Planck who wanted to do this, and rightly wanted to do it, and it's their initiative. So thank you very much for having the initiative, and we're proud to have you here, Peter. I propose to say no more at this stage, because I've got my own judges panel later, where you can all form views of the judges, which may or may not confirm your earlier impressions. One vital message to all speakers: you've got to have this gadget. You can wear it in your tie, not because you want the people at the back to hear, but because the recording machine, which is going on in the background, and everything you say is being taken down and used in evidence against you, needs this thing. And we're apt to forget it, which is why I'm mentioning it to all the speakers now. Peter, yours.
Thank you, David. Very kind. I may have had the idea, but we wouldn't be here except for you, Robin, and UCL providing all the framework, and for all the great speakers being here today. So it's really amazing what became of the idea. Very happy to introduce today. I'll cut it short as well, because we have so much on the plate for today. A couple of weeks ago in a Swiss arbitration, two lawyers told me that in previous times they would have done that before state courts, except other than in arbitration. And the one was very sad about it, and the other one very happy. So I think there's much to discuss on the topic. You will find all information on speakers and the sessions in your materials or on the website. Our first session will be a two-part session. We will have at first Ignacio de Castro from WIPO and Trevor Cook from WilmerHale, New York, giving us an update and kind of the background on FRAND case law and WIPO FRAND arbitration options. And then we will have two members of the Munich IP Dispute Resolution Forum, Claudia Feller and Raphael Probst, who will present the IP ADR guidelines. I will say nothing more on them because I'm a co-author, so I can't, I should refrain from saying much. So, and this will be our first session. I think we start right away because we have less time than topics. So all the speakers, floor is yours. Thank you.
Good afternoon, ladies and gentlemen. Yes, my name is Trevor Cook, and I'm going to kick this off with the first half of this presentation about FRAND case law in the ICT sector, the telecoms and related sectors, and the WIPO FRAND ADR guidelines. Ignacio will take over from me halfway through. Ignacio de Castro from WIPO, and the Deputy Director of the Arbitration and Mediation Centre there. But I'm just effectively going to set the scene at the outset and really identify the nature of the problem. Right. Well, this litigation over standards is really a very recent, relatively recent development, but it has been exacerbated and could become ever more important as networked systems and the standards which allow those networks to operate are developed, and we've seen them, of course, in telecoms, and many of the disputes which have happened to date have been in the telecom sector. But of course, we have the Internet of Things coming along with intelligent refrigerators, and we of course also have standards in relation to the developments in electric and automated vehicles. And so standards and issues surrounding standards are going to be with us for the foreseeable future and are getting ever more prevalent, and we need a way of resolving them sensibly. And these standards are backed up by patents, and the problem with patents in the standards sector is that there are an awful lot of them. There are so many of them that it is hard, if not impossible, sensibly to take a view as to the infringement, essentiality and validity of all those patents. And in the old days that didn't matter so much, when people just used to balance the numbers of patents against each other and didn't look into those things like that. Now they do matter. Now, when you have also the relationship between the standards and the standard setting organizations which establish these standards, and the idea is that the rules of the standard setting organizations require that people who are making proposals for incorporation of their technology in a standard make a declaration of essentiality. They say they assert their patent is essential to the standard, and that they are prepared to license it on such and such terms. Now, there are some standards organizations which actually mandate licensing at zero royalties, but most of them, and certainly ETSI, the one we're concerned with in relation to telecom standards, and most of them require that a commitment to license on FRAND, if you're European, or RAND, if you're American, namely reasonable and non-discriminatory terms, which has attracted an awful lot of discussion as to what is meant by that term. And of course, as in any situation where you have a potential for patent infringement, even though these licenses are available, the question is, what is the appropriate royalty for those licenses? And you have a wide disparity between the rights owner and the implementer. And the difficulties in actually determining the FRAND terms, well, people have to declare their patents essential to the standard. You know, if they're putting them into the consideration, but they may not actually prove to be taken up. They may not prove, when they're ultimately prosecuted through to grant, to be essential to the standards. Indeed, there have been studies out there which show that a relatively small proportion of patents actually declared essential to the standard are actually essential to the standard when you actually analyze them fully. Also, I mean, this is not like a patent pool where you do actually have an expert determining whether or not a patent is essential to the standard. These things are just disclosed, and people are encouraged to disclose them and to make these declarations of essentiality. The other issue is one of validity, and that is not investigated by the standard setting organisation. And indeed, the reason why we haven't in the UK had any determination as to what constitutes a FRAND rate until relatively recently in the Unwired Planet and Huawei case was that no patents which had been declared essential to the telecom standard had until that point been actually determined to be valid and infringed by the implementer. You might say this third point, how does infringement differ from essentiality? Aren't they one and the same thing in relation to a standard? There was an English case a few years back where actually it was demonstrated that even though a patent was essential to the standard, it was possible to do a workaround which didn't infringe the patent, but which actually got to pretty much the same result as required by the standard. And finally, you have this sort of the impact of competition law, the question of whether an originator is in breach of its FRAND commitment by seeking to, by demanding an unfair royalty and by saying it will seek to enjoin the implementer if the negotiations fail, the so-called hold-up situation, as opposed to the hold-out situation, which a rights owner would accuse an implementer of undertaking if it doesn't actually enter seriously into negotiations. Now, the problem we have, and the reason why arbitration is so interesting in relation to this, is that national courts have jurisdiction only in relation to their own patents. determining the validity of patents in their own jurisdiction and determining the subject to Brussels regulation and stuff like that, determining matters of infringement in their own jurisdiction. But on a general, and that's the question of the Brussels regulation is only an internal European thing, but on a wider international basis, you have that international jurisdiction issue. Now, the next couple of slides, I wasn't responsible for drafting these, and having read them, I don't entirely agree with some of the characterizations of these cases. I must make that clear. But they just give you a flavor of some of the ongoing disputes. And there are three particular jurisdictions I would identify which have been particularly active in this area: the UK, China, and the United States. Now, the big current excitement is that first one, Unwired Planet and Huawei, where the court determined that actually a license of UK patents was not be FRAND, and that you had to, the only FRAND license would be one which was incorporated patents worldwide. And so it was actually making an assessment in relation to non-UK patents. And then it granted the so-called FRAND injunction, which said, if you, the implementer, don't actually take this license, which we say is FRAND, then we're going to enjoin you in the UK under these standards essential patents. So you have, and that went, so at first instance you had a long determination as to what actually was, in terms of royalty rates and FRAND. The only three issues went up to the Court of Appeal. The most critical of those was the question of, did the court have jurisdiction to effectively coerce the implementer into taking this so-called global FRAND license? Court of Appeal said it was, but that has now been appealed to the UK Supreme Court. Last week, the UK Supreme Court indicated it was going to take that appeal. The indications are that that will be heard later this year, which is relatively fast for the UK Supreme Court. So that is a very current, very exciting development. The last of those cases, which is the most mischaracterizing quote, because I don't think the High Court declared anything of the sort. That was what the High Court thought the Chinese courts were saying about not being able to determine these other matters in terms of having jurisdiction to determine FRAND rates in respect to non-Chinese patents, because the UK court, in assuming the jurisdiction that it has in Unwired Planet and Huawei, is at the moment an international outlier. The conversant Huawei are also the matter which has gone to the Supreme Court also pulls with it the conversant and Huawei case, which there has been no determination as to FRAND, but it's a jurisdictional dispute in relation to this extraterritorial jurisdiction. So given the time, I don't think I will say any more about those cases, except to point out that I've identified this problem of, pragmatically you could say, yes, licenses in this area between willing licensees and willing licensors are determined on an international basis. Negotiated on an international basis. That's negotiation. Is it open to a court in a single country to effectively assume that and to impose those license terms on parties when that implicates patents outside its own jurisdiction? But that is something which arbitration can do because it is consensual, because the parties have agreed to the jurisdiction of the arbitrator. And indeed, when you look at some of the court decisions in China, for example, they agree that the court could do it, or might be able to do it, if both parties agree. But in arbitration, it's implicit that you have both parties agreeing with that and taking an international view of matters. and indeed, this is one of the great benefits of arbitration. You can take an international view of matters. And indeed, it's one of the reasons why, in fact, in practice, you see fewer of these sort of disputes in the courts than you might otherwise think, because there are a lot of these disputes already the subject of arbitration. Because when you have two established parties entering into a license agreement in this area, typically in relation to one particular standards technology and with a capture year of, say, 5 years for patents, there will be an arbitration clause in that agreement which provides for the next 5-year capture period and for further add-on standards in that area. So a lot of these disputes between the established players are already subject to arbitration. And what we're seeing in terms of litigation is a tip of the iceberg between the new players who reflect industry rearrangements, who reflect some parties who, having excess standards essential patents, have sold them off to venture capital companies and so on and so forth. Arbitration is taking place. This is not really a novel idea, but of course what we really see is the tip of the iceberg, and is the litigation which which is up in court, which is why you have all this focus on cases like Unwired Planet and Huawei. And you see in this slide of various ADR options, and this is the final point I want to make, is that all of these emphasize, even though these are court orders, these all emphasize the consensual nature of arbitration. These do not impose arbitration, but they say arbitration would be a good thing. So with that, having said arbitration would be a good thing, I shall hand over to Ignacio.
Thank you very much, Trevor, for your overview. Good afternoon. I will try to use the remaining time to present WIPO arbitration and mediation for FRAND-related disputes. I think I don't need to explain the difference between mediation, arbitration, and expedited expert determination. You have copies of the WIPO rules. Of course, I would be very happy to answer any questions on those if we have time. Back in 2017, we started realizing that although traditionally most of the patent disputes that we saw coming to mediation or arbitration at WIPO related to mechanical disputes or life sciences disputes, we were starting to see that the telecom sector was a sector where there would be an increasing number of disputes. We see that also from the activity in the Patent Cooperation Treaty, where the top filers of PCT applications now are the telecom companies, and in particular Asian telecom companies, Huawei, ZTEC, Samsung, etc. So what we did is we tried to establish some new guidelines and model agreements to facilitate the submission of disputes in situations where the parties may be involved in FRAND negotiations, and to facilitate the submission of those disputes to mediation and arbitration. And I'm going to explain a little bit what we did at that time. So we developed these submission agreements, which are really targeting these type of disputes that Trevor has been describing. It's mostly, of course, about the determination of FRAND terms, but it can go beyond into the other areas that have been mentioned by Trevor, such as essentiality, validity, infringement, or cross-licensing. We developed clauses to facilitate the submission to mediation and arbitration of these disputes, and we have created a document which has been shared with you, which provides for different commentary on the clauses and also on the procedural order that is included as an annex to that document. As Trevor has mentioned, really the advantage of mediation and arbitration is that you can adapt the procedure to the specific dispute, starting with the scope. The scope, of course, the fundamental scope is the determination of the FRAND terms, but you can also go into the determination of which patents are we looking at. Is it the whole portfolio? Is it a sample of the portfolio? What claims and defenses can be brought in the proceedings? Which of the patents, which of the geographical patents are you going to include? Are you going to select maybe some German patents, some US patents? You can tailor the scope of the procedure and try to make the process as efficient as possible. We have seen this sampling type of situations in other disputes, in other arbitrations, and so we think that this may be a good way to go ahead when we're dealing with very large portfolios. I should mention also that, of course, the procedure, what we're talking about is procedure. We're not really focusing on the substantive methodology to value these patents or the royalty rates. Appointment of mediators or arbitrators, that is done, of course, under the WIPO rules. What we have is we have a list, a database of mediators and arbitrators, and some of those mediators and arbitrators are experts in telecom patents and FRAND disputes. And parties, of course, can always agree on who to appoint, whether that person is not on the list, but we have tried to identify some experts in this area. We also have some online facilities that allow us to facilitate the process. It's what we call the electronic case facility. It's just an online docket to facilitate the submission of documents and the consideration of these cases. Interim measures. Under the WIPO arbitration rules, you have the possibility of interim measures either by the tribunal once it has been appointed, or also to whatever court the parties may want to go to, because sometimes if it's an urgent emergency interim measure, you may want to go to court even before the tribunal is appointed. Under the guidance, under the model agreement, what we have done is we have limited the power of the arbitral tribunal to issue interim injunctions. And that's, of course, because the parties are willing to go to arbitration. So that's what is provided in the model agreement. We have also prepared a tailored procedural schedule, which goes beyond what is normally the standard procedure under the WIPO rules, and that we have based on complex patent cases where there were additional steps and a number of expert appointments, and maybe sometimes even limitation as to the document discovery, which was applicable in that case. As in any arbitration, you need to agree on the applicable law, place of arbitration, and language of the proceedings. So there's nothing special there. In terms of confidentiality, the WIPO rules have got very strong provisions on confidentiality and also on the protection of business secrets, and that is particularly important in some of these FRAND cases because you may have the need to look at comparable licenses. So there, what we see often is some protective orders issued in those cases, and also sometimes you could have the possibility of appointing a confidentiality advisor to the tribunal. Of course, the parties can agree to divulge the result of the arbitration, but in the majority of cases, they want to preserve confidentiality. In terms of the award, as in any type of arbitration, normally the award is final and not subject to appeal. But given the complexity of some of these cases, we have also developed an appeal clause. So you could imagine a two-instance arbitration, which may be needed in some very complex cases, although this would be more the exception than the rule. Of course, these awards are going to be enforceable under the New York Convention, and that's one of the big advantages of arbitration compared with court litigation. You can consolidate the entire dispute independently of the territories in which the patents are protected, and you can also enforce the award of the arbitration award internationally through the New York Convention. Finally, just to conclude, we have also, in addition to arbitration, we have also a procedure for the unilateral submission to mediation of cases relating to FRAND. And this is something that happens when parties may be involved in litigation, or when they decide that their stuck in their FRAND negotiations. And this is something that we are seeing increasingly, particularly when we're dealing with some of the newcomers companies that Trevor was identifying. So we're seeing this in some cases involving some of the Asian companies and some of the traditional European telecom companies. I would be very happy to answer questions if we have time, but for the time being, thank you very much.
So as we've heard, ADR is a particularly efficient way to deal with FRAND disputes. And one of the main reasons why that is so is the flexibility ADR measures can provide. Flexibility that you can use to reduce the complexity of a FRAND dispute, while at the same time you can reach a more comprehensive solution for your dispute, especially on a global scale, and reach a more comprehensive solution than in front of a state court. However, with this flexibility comes insecurity, especially for parties who are not very familiar with ADR measures, namely SMEs and their representatives. It is difficult to envision how a FRAND procedure in their particular case would come down. So the Munich IP Dispute Resolution Forum, with its FRAND case management guidelines, wants to offer some specific and practical pointers to assist parties, mediators, and arbitrators who consider FRAND ADR, mainly by pointing out the peculiarities of FRAND-related disputes and by offering and explaining different procedural options to parties and arbitrators. Coming from a neutral forum, the guidelines aim to balance the interests of SAP holders, of implementers, and also considers public policy.
Okay, so every time you're dealing with complicated, complex cases, so to speak, it's very hard to come up with a definitive blueprint. So it was clear, whilst creating the guidelines from the outset on, that the guidelines cannot and will not direct its readers down a specific path. Instead, they offer an array of options. Now, there are two main ways one can read and approach those options. The first is you can regard them as a menu. So just as in a restaurant, you open the guidelines, you see something that you like, you see something that you feel is appropriate given the circumstances of the FRAND dispute that you're dealing with, and you choose it. The second is to regard all these options as a checklist. So you go through the entire content one by one, and you make sure that every option conceivable is considered whilst moving forward with your dispute. However, once the parties are locked in a dispute concerning substantial issues, so the use of standard essential patents, for example, it is likely that there will be difficulties to agree on procedural issues as well. Now, to this end, the guidelines may offer a third function, because as Claudia mentioned, it is a non-partisan, a completely neutral approach. So its suggestions may carry additional weight in such situations and may provide an acceptable way forward for parties. But what if one party is not willing to engage in ADR proceedings? In this case, the guidelines underline that a party's non-willingness shall not automatically imply that the party is not willing to comply with FRAND requirements. But obviously, on the other hand, if a party is willing to engage in ADR proceeding and is willing to accept the binding decision of a neutral third party, this should indeed indicate that the party is willing to comply with FRAND requirements.
Regarding the content of the guidelines, they start with an introduction into the background and characteristics of SAP issues and ADR mechanisms as such. This is because we have experienced that many ADR experts are rather new to the field of SAPs, and vice versa, many patent specialists are not very familiar with ADR mechanisms. And of course, potential clients, especially when they come from an SME background, might not be familiar with either of those areas. So in light of one of the goals of the guidelines, that is to promote FRAND ADR, we have felt that an informative introduction might help parties to consider ADR in the first place and might help lawyers and representatives to pitch, when appropriate, an ADR alternative to their clients. The second section of the guidelines describes various routes to FRAND ADR. And the third section are the 13 guidelines themselves. I will go into some of them later. And then we have 4 annexes. I only want to point out Annex 1, which is a very informative overview on court decisions applying specific methodologies for the determination of FRAND terms and conditions. We have to thank Andrew Wynn and Mark Besson from FTI Consulting for this very valuable addition to our guidelines. The topics of the guidelines themselves range from suggestions regarding appointment procedures to procedural schedules that avoid the reproach of using delaying tactics to possible appeal proceedings. Here I wanted to focus on defining the scope, transparency, and appeal. I will skip the defining the scope slide because Ignacio has already gone into various possibilities how you can scope your FRAND dispute and some ways to reduce the complexity of your dispute. So I go directly to the dichotomy between transparency and confidentiality. In the case of FRAND arbitration, the outcome of the arbitration is of huge interest to other implementers of a specific standard, to other courts, and of course the public as such. On the other hand, parties will usually be very keen to keep their license agreements and the details of the arbitration confidential. The guidelines attempt to introduce some transparency into FRAND ADR procedures is a model transparency clause that you can find in Annex 3. It provides, inter alia, for limited disclosure of the methodology the tribunal has used to determine the FRAND terms. You would disclose this methodology not to the public, but again to a neutral forum that then would redact it and provide it for other tribunals or the public if needed. This has been criticized, this idea in general, by arbitrators as to compromise one of the key features of arbitration, confidentiality. However, in our drafting workshops, many industry representatives agreed on a need for greater transparency in the SAP licensing area, also in light of public policy considerations regarding the accessibility of standards. With the proposed limited disclosure, the guidelines want to encourage parties to opt for more transparency and thereby help to develop a sustainable framework for future FRAND negotiations and disputes. And third, as Ignacio has already mentioned, usually you don't go on appeal with arbitration. However, many implementers during our workshops called for the possibility of a de novo appeal against a tribunal award. SAP owners, on the other hand, predominantly advocated for the usual final and binding decision in a single-step arbitration procedure. As a compromise, the guidelines suggest the possibility of an appeal with limited scope. Annex 4 contains a proposal for a corresponding appeal clause where parties limit the procedure to review of the determination of the FRAND terms only.
So, as you can see, the guidelines do not attempt to seek the broadest possible consensus, but are rather a neutral proposal for balancing the various interests concerned. Now, in order to achieve this, a carefully crafted development process had to be drawn up, and I will just very briefly touch upon this because it's really something that sets these guidelines apart. We needed to make sure that neutral experts, as well as opinionated stakeholders, could participate without one side dominating the process, without one party just dominating the whole process, or the danger of having one's open words used against oneself later on. So it was really, really important to draw up a process where we could balance these interests. Now, the first step was of this process, it spanned from 2015 to 2018, and the first step was to involve important stakeholders. The guidelines benefited greatly from different viewpoints, experiences, and candid opinions, and that wealth stemmed from a number of executives representing both patent holders and implementers. It benefited from neutral organizations chipping in, judges, academics, and of course, a lot of lawyers. Once all the stakeholders were involved, we tried to come up with a framework for a development process. So to ensure transparency and to provide a safe environment for stakeholders to freely speak their mind when it comes to the strategies that they usually employ and the expectations that they have. And we realized that two different formats were actually needed. The first format were open sessions. Those allowed for very broad discussions in front of general audiences and were the basis really to create an active network of practitioners from the world of the IP and ADR. And I'm going to come back to this network later on. The second format were closed workshops where, under the condition of anonymity or Chatham House rules, participants could openly argue for their positions and present their viewpoints. So we could learn about that and later on discuss, distill, implement, and review. Because this alternation of open sessions and closed workshops allowed for a certain review circle where new ideas could be discussed and an effective balance between every involved interest could be found, or at least could strive to be found. However, the process does not stop there. The guidelines are a living document, and they will be curated and updated in accordance with new developments. This process has been and will be transparent and open for all. And we believe that the complexities and challenges of FRAND disputes leave parties in need for orientation and sometimes guidance towards agreeing on tailor-made approaches for their unique dispute. Obviously, this can be provided by neutral guidelines. There are a handful of these guidelines out there right now, and in an upcoming version of the guidelines that we are presenting, the guidelines 2.0, if you will, there will be actually a synopsis of the various guidelines available, mapping out the different approaches that every guideline has taken and the decisions taken by each one of them. Really, the key to having the guidelines circulating, to getting them out there in the real world, is updating the content. And therefore, input is really needed. This is where I come back to the network I was referring to earlier on. The IP Dispute Resolution Forum, it has started out in Munich, but as a matter of fact, right now it is a truly European initiative. And during the drafting process, not only the guidelines were created, but also this active network that has created and contributed to the creation of the guidelines. This network obviously is open for all, and it is not a lobbying organization. It is a distinctively neutral forum that strives to provide orientation for corporate and legal decision-making in IP disputes. So with this thought, we're obviously closing this presentation. We hope that if you haven't read the guidelines yet, you might have an interest to do so now. So feel free to approach us at any time. And if you're interested in further activities of the forum, just contact us. Thank you.
Thank you.
Before I suggest we open it up to Q&A, I'd like to ask Judge Rader to come and talk about what's happening in Japan about dispute resolution. You've got 5 minutes, Randy.
Sure. That's plenty. Seeing the need for IP expertise to resolve these international disputes, we have founded the International Arbitration Center in Tokyo. IACT is its acronym. It features IP experts from the nations of China, Japan, Korea, United States, and Europe. Is England in Europe?
Very good question.
Okay. Because one of the retired English judges of note we have put in the European category, but the IACT has offices, bank accounts, staff, places to hold hearings in Tokyo, if that should be the place where the parties would like to appear. The center is expecting its first case in the next couple weeks. It's just been up and running for a couple months now. And it has a particular emphasis on resolution of FRAND disputes and hopes to be able to use world IP experts to do that. It has two objectives. One is to finish those arbitrations within a year of the appointment of the panel, and it has a limited appeal mechanism to a panel of 5 experts, one from each of the regions that I've mentioned before. The hope is that this can form an alternative in Asia that will be of great interest to resolve the coming flood of 5G IoT disputes.
Thank you, Randy. What this illustrates so far, as you can see, is everybody's having a bash at it around the world. And then we have the courts as a sort of, they are the true alternative dispute mechanism, actually. You know, if you can't do it any other way, you do it to the courts. So it's the courts which are the alternative. Nobody's ever really appreciated that. My dad used to say it when they were starting talking about ADR. He said, but that's what the courts are for. Probably the world has got to develop some sort of systems, and what they will be, it's too difficult to say. One of the reasons for Asia getting involved is, after all, that's where most of the bloody things are made. And it's not unreasonable that a Chinese company ought to feel that there's a Chinese arbitrator who's on the panel. So I think we're beginning to look at something much more worldwide than we've had before. Right. Questions and comments?
So my question is about, well, it's really for any of you on the panel, and it's about the extent to which you're concerned about enforcement in Europe running up against European competition law. So, for example, if you have had an arbitration and the arbitrator or the panel has just determined the FRAND royalty rate and the license, and then all of a sudden you find out that a third party unrelated to the arbitration has now invalidated a handful of the most crucial patents in the US, for example, thus rendering the supposed FRAND rate not FRAND anymore. And could this create a problem with enforcement in Europe? Obviously, it's contrary to European competition law.
Well, I will hazard a view, and it's, sorry, I've got to do with this one. I will hazard a view, and it's not limited to these FRAND disputes. It is also an issue which has arisen or has been raised in the context of life sciences disputes. And it seems to me that effectively you draw the analogy between between an arbitration and a negotiation between two parties. It may or may not be at the end of the day that the deal which two parties negotiate is in breach of competition law. But what one can say is that a result which has been achieved by arbitration is probably going to be less likely open to challenge than a private deal just negotiated straight between the parties. So I don't really see that there's anything, I don't really see that competition law raises an issue which isn't already there with any negotiated license. And if you like, arbitration is just a way of formalizing a licensing negotiation by involving a third party with the powers that the arbitral clause has given to that third party.
I think I rather agree with that. It's also a bit odder, the idea that an agreement or an arbitration award, which is apparently, and indeed is, perfectly lawful as far as competition law, becomes unlawful because of some decision of some court saying some patent's no good. I mean, you had the choice before you did the deal of knocking out the patent. Now, I know the competition lawyers may think that they can overrule everything, but I think they might find it difficult, in fact, to do that. Do you have any views on this one? You must have thought about the same thing.
I would agree with both of you, but I would also say that we haven't really seen any cases where this has been yet. But of course, as Trevor was mentioning, it's something that we could see also in some of the life sciences cases. And at the end of the day, the arbitrators need to apply competition law.
Yeah, I mean,
I think I
just the most spectacular would be a life science case, not a FRAND case. There'd be bunches of patents, so they knock out some, but there's still lots left. But a life sciences case, the chap takes a license, and the patent is then knocked out by a third party, and that's the only patent in town. Does the licensee have to carry on paying? Well, I'm not going to answer that.
Thank you. My name is Annette van Hoofd, and I just wanted to pitch in because I've had the case in a life science situation where there was very much, in fact, it is a case that is public. It went before the ECJ. It's Sanofi Genentech. And that was, in fact, one of the issues. What happens if the patent is invalidated? And in that case, the arbitrator came to the conclusion that, given the way the license was worded, that didn't render at least the obligation to pay royalties for the period that the license was in place, didn't render it invalid. So you cannot jump to the conclusion that a patent is invalidated and therefore automatically license fees violate, the payment of license fees violate European competition law. It's a bit more subtle than that. But it is an interesting question, and it's interesting to see where it goes from here. Absolutely.
Right, another question or comment. Yes.
Hello, Juliana Borinski from ZTE. Only a small comment, because I think in practice most of those things are more theoretically problems, because you can have adjustment clauses in license agreements, really dealing with such matters if something changes over the time. And this is, normally I would say, have a good adjustment clause and you don't have those problems we are talking about here.
Chris.
Matteo talked about something I've never heard of before called unilateral mediation, and I was just inquisitive to find out how you can have a unilateral mediation and what the effect of it is once you have gone through it.
Maybe I was not clear. It's a unilateral mediation request. So it started by one party. It needs to be agreed by the other party. You cannot appoint a mediator. But what we are seeing is that as a result, in particular, of the European Mediation Directive, which of course has been implemented in most European member states, the refusal to participate in a mediation can carry consequences. And therefore, in that context, a unilateral request for mediation can be quite useful tactically.
It's not such a request, it's a statement you're willing to mediate.
Absolutely.
Geoff Wild from IAM. A bit more practical question, just to talk about incentive. Is there an incentive at the moment for parties, say in China, to get involved in arbitration when in a lot of places around the world the courts seem to be doing quite a lot of what Chinese companies want to do with regard to FRAND rates and SEPs?
Who would like to answer that? You go for it, Trevor.
Well, I think it's probably a question for the next panel where we have somebody from ZTE.
I mean, they've got an incentive. Everybody's got the same incentive because it's no good saying, well, I'm in China. I want to sell phones in Europe. So I've got to have the same incentive to whatever it is. I have to say in my own comment about the willing licensee, I've been bursting to say this. This is the most ridiculous concept which has entered into the whole gamut of this thing. It's invented by, I don't know who, something competition lawyers, I dare say. On the principle that somebody who is willing to negotiate is in a different position from somebody who says they're not negotiating. They're not. The only willing licensee is a man with a pen who signs. Until he signs, he hasn't. That's called contract law. What you can say is somebody who's willing to abide by the result of an arbitration is a willing licensee of a different sort, very different sort. He is, in fact, agreeing to pay whatever is fixed by the arbitrators. He is not just a willing licensee in a woolly sense. He's going to have to pay if he loses the arbitration, or pay more, because it's nearly all about how much. And I know I find all the discussion in all the cases that went on before Huawei absolutely peculiar. Is this person sufficiently willing? And not helpful to the discussion at all. I think my own view is that the concept of a willing licensee is a very dangerous concept in thinking about it clearly. Does anybody disagree with that? I wouldn't mind if they did. So I'd like to know what the argument the other way is.
Well, I'd only add that that person can be a willing licensee if he agrees to pay the royalty fixed by the court as well.
Yes.
Yes, I think it's a term. I think you're absolutely right, but I think it's a term which has emerged from the sort of language of the English courts of years gone by, where you had a notional royalty rate fixed in relation to the notional willing licensor and willing licensee, and everybody knew there was no such thing as a willing licensor and willing licensee.
We were doing it in a different context.
There was, in a different context, and with a balance, at least, between these two entirely hypothetical creatures.
Yeah. Actually asking whether a real person is a willing licensee is a daft question. But licensees can behave very reasonably or behave unreasonably. That's a quite different question. Potential licensees.
What's the perfect arbitration panel? Just ex-judges, or should there be economists, industry experts? What do people think? For these sorts of disputes, competition lawyers?
Yeah. Ignacio, you run panels all the time. You tell us which is the best.
I don't know. I think what is important is to have maximum information, and each case is different. But I think we feel that the standard commercial arbitrators may not be the right arbitrators for a FRAND case. So in a way, what we feel is that this is an area where there's a lot of issues which are very technical. There's people who have their entire careers around licensing, patent, telecom, patent standards. So I think it's important in each case to choose the right arbitrators. Former judges, yes, why not? We have former judges, including a number of the participants here who are in our panel. They get appointed in certain cases. I think each case is different, but I think it's good to have a maximum number of huge choice. And then, of course, where we are facing an issue is now in some of the Asian jurisdictions where there is less tradition of arbitration. So there, I think we need to identify new arbitrators in those jurisdictions, particularly in China.
Randy?
Where parties appoint an arbitrator, is there any danger that that arbitrator will feel obligated to that appointing party in the future? And is there any way to guard against that sort of prejudgment bias?
Well, I don't know. My own experience with arbitration is I can't see how you can avoid it. If a party thinks, if an appointed arbitrator thinks they are there for the side that appointed them, what can you do? I just want to go back to your question, because I've got a thought about that. I think acceptability of the panel is quite important. And one of the advantages of the Japanese system is you really can have arbitrators from all the continents. And therefore, it's got a more worldwide acceptance than a bunch of Americans or a bunch of Europeans or just a bunch of Americans and Europeans saying for the rest of the world. And I think that's really important. It's one of the real values of bringing in an ex-Chinese judge or an ex-Korean judge to the panel. And I think that may be one of the ways forward in the world. One other point I'd add is I sat as the copyright tribunal sometimes, and I sat as a really big one, how much English record companies, in the days when there were records and even tapes, had to pay for the use of music to all the music publishers. So it was a huge amount, about 6% of the value of the cost of the record. And of course, the Copyright Tribunal is statutorily imposed, so you just get it. And the tribunal did consist of a mixed bag, a couple of lawyers, and an ex-senior civil servant, and I'm not sure, we might have even had an economist. And it worked terribly well. But of course, that's an imposed panel. It's not an arbitration panel. But it was a panel of all the skills. I'd like to see that, if that was possible. At the moment, nothing that's being put forward advances that. Yeah, Chris.
Either those two arbitrators, once they've been appointed, or the arbitration organisation appoints a third neutral umpire, and the neutral umpire has to write an award at the end of the arbitration process. And so even if the party-appointed arbitrators are arguing the case of those parties who appointed them, the neutral umpire hears those arguments and decides between them. My personal experience of being in that situation was that I found myself at one stage arguing the case for the party who hadn't appointed me, and the party appointed, the arbitrator appointed by the other party was arguing the other case. And the umpire noted that how he thought that was a rather satisfactory way in which to proceed. I think once you're in private session, you forget about who's appointed you and you try and get to the right answer.
Gavin Pope from Novartis Pharma. So just coming to that point, I had an interesting example of a case where in an arbitration, one party had appointed an extremely biased arbitrator in their favour. And it's a dangerous game because in a three-party panel, exactly what was just described happened. And in fact, having such an extreme arbitrator on one side drove the other two, in other words, a neutral arbitrator and our arbitrator, if you like, together. And in actual fact, from that point onwards, the biased or heavily biased arbitrator was pretty much excluded from a lot of the discussions by the lack of credibility of their arguments.
Sounds
And
just
ultimately
like the Court of
everything
Appeal.
right. And everything went through on a majority. Yeah. Thank you.
How are we doing time? Done? Peter says our time is up. Sorry, thank you very much, panel.
So great, we are still on time, and we have touched upon all the major, or most of the major issues already. So I think this is the perfect setup for now collecting some views from major industry players, really. As you can see from your materials, we have with us Juliane Buchinski from ZTE and Clemens Heusch from Nokia and Ralf Urich from Google. So both persons and companies that are very knowledgeable and big players in the field. We decided not to do slides and start discussing right away. And we decided that I say at the outset something that otherwise each participant of the panel would have to say before each statement he or she makes. Namely that all persons present on the panel today, including me, but it's really the least of a problem, are making their statements and explanations exclusively on their personal behalf and not speaking for the companies they're representing, or rather not representing today on the panel. So with this very important caveat, please keep it in mind. If I see in your eyes that you are about to forget it, I will repeat it from time to time as we go on. So with that, I would like to really take up the discussion that we were having a couple of minutes ago already on maybe pronouncing a bit the aspect of advantages and disadvantages comparatively of state court litigation and ADR. This is, of course, an evergreen. Probably there is not a yes or no answer, and most certainly there is not an answer that would be valid for all types of ADR and all regions and all cases that exist in this world. So we decided to tackle the important topic a bit region by region. And I would maybe ask Ralf to give us his views first, and focusing a bit on Europe. So how do state court litigation versus ADR, how do they do in Europe?
Yeah, that's a pretty broad question. So I think state courts have been traditionally used for FRAND and CEP litigation, as we all know, right? And we have some of the leading cases coming up to the highest courts in the respective jurisdictions in the United Kingdom and in Germany. So that's going to be very interesting to see. I think there's a settled body, a certain body of case law, I shouldn't say settled, for the major jurisdictions in Europe. So I think that's definitely a plus for the so-called state courts. I think some of the industry stakeholders sometimes feel that the process can be a little bit prohibitive, rather formal, depending on which jurisdiction you're litigating in. And so I think one of the upsides could potentially be, as we've heard earlier as well, the flexibility of ADR proceedings when it comes to FRAND determinations. I want to point out maybe one issue with that, with the flexibility, may also be that the flexibility requires the parties to come to a table and agree to a certain scope of the proceedings, and I think that can be, in practice, a real challenge to agree to a scope that can be handled by a panel. So while on prima facie it's a very good thing to have that flexibility, I think it can also be a tricky part to come to an agreement as to how you want to approach a proceeding. I think if you just look at the case numbers that I'm aware of, I think courts are much more used than FRAND ADR, I think, in Europe at the moment. So I think that's a given.
I remember a high German judge. Yeah, sorry. Yeah. I remember a high German judge, by the way, not one of those being present in the room today, answering to the question, well, you know, you are now confronted with those SCP cases and you have hundreds or thousands of patents from diverse jurisdictions, and how do you do that? I mean, it's such a workload. And he was like, well, we take them patent by patent as long as they're German ones, and the other ones we rather don't look at. So this is, correct answer in a way, but also made me question whether this is the best approach to those FRAND portfolio disputes, where really much is about the price tag for the entire portfolio, or the relevant part of the portfolio. Would you say that European courts, or maybe some court systems in Europe, are too patent by patent to tackle those disputes properly?
I wouldn't think so. I think the patent, one could take the view that the patent is merely the vehicle to come to a FRAND determination, and I think there's not really, in the end of the day, not a huge difference between, say, the German approach and the approach that the English courts take. I think it looks different, and some commentators call it jurisdictional issues, but I think at the end of the day, the question is whether it's common practice in that industry to negotiate about a global FRAND license, and then I guess the current approach in the major jurisdictions is that it only takes one patent to have that discussion, really. So so I don't think it's too extreme to have this. I don't think it's too much patent by patent. Let me put it like that.
Okay, we will certainly at the latest with the judges panel have the discussion of whether one patent gives you the right to set a global FRAND royalty. But okay, let's move on. Maybe Clemens next with a focus on the US. What's your view?
Thanks, Peter. Yeah, when I come to the US, we used to have much more litigation in the US than we have in these days. I think the reason is quite simple, because litigating SEPs in the US at the moment is quite difficult. What they do in the US is mandatory mediation in many cases, which we consider to be quite useful. But otherwise in the US there is the eBay case law, which means that getting injunctions on standard essential patents is more or less impossible. So what do you get? You get damages. But damages are calculated for the past, and as you mentioned earlier, the aim of this dispute is usually to come to a full peace, to a global settlement. And if you have to litigate past damages patent by patent, which is the case in the US, there are no merits. I mean, if you have, let's say, one key patent and you think you get all your revenues by this one key patent, it might make sense. But if you try to license a portfolio of 1,000 standard essential patents, that is just not doable. So this means in US state courts, you will probably not come to the result you as a patent owner would like to achieve. Well, then there's the FTC, which has become, I would say, the most attractive tool in the US in the last couple of years. The issue, the original purpose of the FTC was to keep, let's say, patent infringing products out of the market which are produced abroad, so from European or Asian companies. It turned out a little bit to the opposite, because now also the American products are mostly produced in China, so it hits a little bit back. I think, yes, for example, Apple produces all their products abroad. So therefore, I think this is not what was originally the intention here. The other problem in the US, from my point of view, is, of course, that there's no loser pays system, as we know from most European jurisdictions, which means, of course, that, let's say, the threshold for these one patent, non-patent practicing entities is quite low, and so therefore I think they still have a lot of litigation, but I have seen not so much litigation between, let's say, the bigger SAP holders, unless, of course, they are dragged there, as we have seen in the TCL case, for example. But to conclude, I think this mediation in the US is a good thing, which is always worth trying. And in Europe, for example, it only works if both sides agree. In the US, they are pushed into this, and this is something which might be worth a try.
Thank you. So for those cases which are not resolved by mediation, do you think that they are wandering away into ADR? So is there a trend in the US that cases where you wouldn't want to see only damages awarded and where there is no successful mediation, that they increasingly go into arbitration or other forms of mediation?
Well, the problem with arbitration is that you don't really know how many arbitrations are going on. A lot of those never become public. Trevor said it, one of the, let's say, the big numbers of arbitrations are because there's a previous agreement, a license agreement, which expires one day, and then there's an extension clause, which includes arbitration. So that is one of the, let's say, big sources for arbitration. The other source is indeed if both sides agree that they want to grant a license, that they want to take a license, and it is really just about finding the right place, the right price. We have seen a couple of such arbitrations. That is, in my view, a possible tool, a good way to get ahead. But this, of course, requires that both sides agree to this kind of arbitration. And in my personal experience, that is not so easy because you can, first of all, you must accept that you have to pay at the end of the day. And this first step is not so easy for at least some companies out in the market. Then the second problem is that even if you agree to arbitrate, there are so many questions to be discussed, and I have seen discussions taking on for a year or longer just about the applicable arbitration rules. And ICC, for example, has no specific FRAND arbitration rule, so then you discuss about how FRAND should be determined. You can discuss it for a year and then come to the conclusion that you don't come to a conclusion, and then you start from scratch. So it is not so easy, and that is the reason why I think there have been some arbitrations, but I'm not aware of so many, and I would be surprised if it was, let's say, if it was a considerably high number at these days.
Okay, yeah, very interesting. So question is whether this year of negotiating about how to go on would count into the year in which, if I understood it correctly, the Asian arbitration, Tokyo arbitration institution would have to resolve the case. So I'm not sure about that. Probably not.
Randy just left the room, but he would probably say no.
Yeah, we will pose that question to Randy later on. So, Juliane, I enjoy a lot that you were ready to say something about China in this respect, because I think for most of us at least, the Asian jurisdictions and maybe China is getting a bit better, but in general, Asian jurisdictions are harder to grasp than the European or US ones. So please inform us.
Okay, I can share whatever I know about it, but I must say that I'm the Europe litigator of CIPCO. That means all the cases I'm normally dealing with are here in Europe and not in China. But what I can say is, yes, as everybody knows, also from the case law, that China is getting ready, to say it like this, also to become one of the players, also in litigation of FRAND disputes. And as you see, always also before in the panel it has been discussed that, of course, we have the courts here in Europe dealing with those cases. We have US courts, and now we have Chinese courts to deal with this. And I think this is one of the things, because you asked very generally what is a good thing about the state court system. It's about trust. That means as long as everybody is trusting whatever is outcome of a litigation also in a state system, and I think this is something what China is trying to build up here, to have more case law out which is trusted in a way, then this is a very good thing to go. On the other hand is what maybe something positive about IDR is in case law, we have seen this in all our FRAND cases. The case law is changing very fast, and it's a bit also unpredictable. And that means even as a patent holder, you go somewhere, you even have different opinions in Germany between the different courts in Munich and in Düsseldorf and in Mannheim, how to proceed and how to go on, and even have their conflicting ways of looking into how to, for example, the requirements of the ECJ are fulfilled or not. And then you have new ways of looking in the matter from the UK courts and so on. That means if you go into such a thing, it could become a global battle. And none of the parties know what will happen, because of course you can also file counteractions. You can go on, and you even can go to courts which nobody really ever had on the table. I only want to share some knowledge because we had a case where an NPE started on a SIP litigating in Romania against this, and got a preliminary injunction without a hearing before. saying literally everything what is somehow LTE has no chance to come in, and the only way to get out was like, yeah, you can have the main proceedings, but they will take 10 years. Sorry guys, if you get an injunction like that, you are out of the table. And this is something what I meant. If a court system, and the US court system and the European court system and also the Chinese court systems are very trusted, they are very good places to deal with those things. But if you really want to avoid those global battles which go crazy, to say it like this, I think that IDR is a very good way to deal with this. But as Clemens also mentioned, you need to find a way in a very early stage to sit together as parties and agree to a lot of things, and even this stage could be very complicated. If the parties don't trust in a level they maybe should trust each other.
Yeah, thank you very much. I mean, I think it was Unwired Planet case where anti-suit injunctions were discussed, because after the first decision, both parties ran to other courts, including Mexican courts, to relitigate things that had been decided in the UK. So certainly not a theoretical problem you have been describing. We are, I think, 10 minutes into our panel, and before asking my next question, I would like to repeat the caveat that everyone is speaking for her or himself only and not for the company, because I would like to dig a bit deeper into the topic touched upon by my first question, and ask you, touching a hot potato, of course, as far as you can tell from your very personal experience, what were your impressions from the ADRs you were personally involved into, or that you could, follow closely, kind of, because colleagues from your firms or former firms or former law firms or whatever had been dealing with them? So what are your very personal views, again, as far as you can tell? Clemens, maybe?
Happy to start. I mentioned already mediation, where we did make good experiences, but as I said, these are few cases. Regarding arbitration, I think you don't have this jurisdiction challenge, so therefore it is an obvious way to deal with these things. And we have seen, especially in Europe, for long years that judges were reluctant to put a price tag on it. In Germany, for example, there were many decisions where courts found different reasons why it was not up to them to put the price tag on it. Has changed a little bit now. They at least look at FRAND offers. They make at least thumb up, thumb down, but still we see quite reluctance here. So ADR is a possibility to come to a solution for arbitration. We have done several FRAND arbitrations. It is at the moment still, from my point of view, very challenging, very expensive, very time consuming. I think one of the reasons is because there are so many different economic approaches how to come to the right value, and both parties don't really know which is the right one, so they plead to be on the safe side, all 3, 4, 5 different ones, to kind of be on the safe side. And my hope is that also with more transparency we will come to a point where this will be getting simpler, where we have, let's say, not the 5 approaches, but maybe 1 or 2 approaches, which bring us closer, so that we can do this in more cases with less budget, because the costs of these 2 arbitrations we heard were so enormous that is something you cannot do with more than just maybe a handful of companies in the world.
Okay, thank you. So specific SME, small, medium enterprise arbitration forms. We'll get to that in a moment, but maybe first, Ralf, some personal views or experiences, rather.
Yes, two cases come to mind that I did when I was still outside counsel in my previous life. Definitely nothing to do with Google. And one of them was an binding arbitration that involved a patent family, and there was like five patents valid across Europe, and that was dealt with fairly efficiently. I mean, there was still an awful lot of evidence being discussed for German standards, that is. So, but I think this was a very good setup, and it was really about whether the patents are valid between the parties, right, and whether the accused embodiments would in fact make use of the patented invention. And so that was a very good example. I think they resolved this dispute very efficiently. And quite the opposite example was an arbitration that involved over 100 patents, or should have involved over 100 patents, and that was not really, that was very hard to manage. So the parties had a dispute going on all across the world, and then eventually they agreed to a license, but they didn't agree to the magic price tag. So basically, they had a fairly boilerplate arbitration clause under ICDR rules, and that's that. And then we had to deal with 100 patents. No one, the parties hadn't contemplated how to deal with that. No one knew whether it should be sampling or not, and how to sample the assets. In fact, the proceedings were so contentious that the first arbitrator we proposed, who's actually present, but I won't look at him or her, got dinged for no reason whatsoever. So it was really contentious, every single aspect of the arbitration. And actually, before we ever got to a procedural order number one, the parties settled, because they realized this would probably go on ad infinitum. So we would probably be still doing that.
So in a way, maybe a very successful arbitration, because it.
but I think it just shows like there's no cure all. Like just because you have come to the table once, you should probably think ahead of how to deal with the enormous amount of patents that are involved. And typically for FRAND and SEP scenarios, I think the portfolios are rather large. So it probably makes sense to come to an agreement before, because otherwise you will spend an awful lot of time, if you can, obviously. Otherwise you will spend an awful lot of time trying to agree to something along the road, and like I said, they would still be disputing in that case.
The case would still be underway. So just a footnote question, because that sampling thing, I mean, it's a buzzword. And also the guidelines, all guidelines use it in some way, and it is a promising concept, but I am wondering whether there are any general inroads for how sampling might be done sensibly, except for, well, you have to look at the cases and the facts and the portfolios, and of course it's case specific, but do you see any general rules for how to sample best?
I think it's very hard, because of course the patent proprietor will pick their crown jewels, and the other party will try to pick like the skeletons in the closet, right? And so I'm not sure whether that's really so helpful. One could randomize it. Like we didn't settle on anything in this case, right? I mean, we had a lot of ideas. There was one of the parties brought up the idea of like having a expert hot tubbing about the sampling of, so another buzzword, hot tubbing, which is apparently done in Australia between experts. So experts have to come to a conclusion and present one view of a certain fact, I suppose, versus then having like the Earth is flat and the Earth is a sphere. So they come to the conclusion it's probably an ellipse or something, right? So I guess everything was contemplated in that, but like we never came to an agreement. We had an awful lot of buzzwords.
Okay, lovely. Juliana, I know you are more a state court litigator than an arbitrator. Yes. So, do you have any experiences, or your colleagues maybe?
I only had some experiences from my former life as well, as a lawyer. And I remember only vaguely, because then back to the time I was a very junior lawyer in a big team dealing with the things. But what I remember, and what is still in my mind, is that it was very, very hard to find the right arbitrators. I think it's quite interesting that somebody says there is a huge list of perfect persons you can choose. But I remember it was, to say it like very pain in the ass, to find somebody who is neutral enough that somebody really agrees on it. And even this, and even minor things have become huge problems between the parties, because this is one of the things, if you are allowed to negotiate everything in the beginning, which is great, but it's really hard to find a common ground how to deal with and how you really want to go forward. Mm-hmm. This is something which can become very complicated. And one thing, because he mentioned was this 1 year arbitration, which is great, but I remember also in another case that some of my colleagues complained very hardly, saying this was the toughest thing they ever done, because all the deadlines have been so short
that they were really working like hell overnight and so on and so on. In the end, this arbitration was also exceedingly expensive because of the lawyers needing to really work very hard in a very, very short time frame. We have this already in Germany because we have quite short times, but those are even shorter, and you have no chance to have any way of delaying anything. And this is something, if arbitration becomes much, much more expensive than litigation, this is not a good thing, right?
Yeah, so thank you for your open statements and experiences. I'm sure in the following Q&A we will add some from the audience. But before that, you all kind of shared the view that ADR can be interesting, but that the present ADR situation, at least in SAP FRAND cases, has considerable weaknesses. And so my next question would be, if you could make only 2 or 3 proposals for how to improve the present ADR system let's focus on SAP FRAND cases for the moment, really, because we will have a life sciences panel later on. What would those proposals be? Do we need new institutions, or do existing players like standard setting organizations or patent offices or the EU Commission or some other, I don't know, player, should they take a more active role or take over part of the game, or should we have more interaction, carve out, another buzzword, carve out like interaction between state courts and ADR institutions, whereby the state court does some things, for example, validity, and the ADR institution does other things, for example, price tagging. So I give you 10 more seconds to think about your 2 or 3 proposals. And who wants to go first?
Well,
yeah?
2 ideas which spontaneously come to my mind. First of all, the ADR, the arbitration, for example, would be much simpler if it is only the price tag you need to resolve. You can, of course, argue about everything. If you say the one wants 3-year license, the other one 5 years, the other one wants a percentage of the product, the other one wants a flat fee, and all these kind of things. So if you could at least kind of exclude all this and say we have a standard agreement, it's just the price tag. That makes it easier. The second point is, the evaluation of portfolios also proportional to other portfolios. That is, of course, something where you can spend hundreds of experts, hundreds of expert opinions, and an awful lot of money. There are good studies, also good neutral studies, PA consulting, others. I think if you just could agree to apply one of those, and then at least you have kind of the value of the portfolio, at least relative to other portfolios. I think also that would make it much easier, much cheaper. So I think if people could agree on, let's say, some of these pre-assumptions to, in the end, focus on the 4 core questions, that would be very helpful.
That was 1 proposal or 2? Or that was 2, okay. Juliane?
It's a very good question, because as I said before, I'm a litigator, but as far as I personally think, it's if you have a chance to make ADR in any way less complex, less costly, and less unpredictable than litigation, then it has a good chance to be a very good. But how do you do that? Yeah, good question.
We will ask Ralph about that.
I was still thinking about my. Sorry, I literally didn't follow the question, actually, because I was thinking about the
remove legal uncertainty, make it quick, and make it very cheap. That was her proposal for how to better things.
Like how to achieve that? I can't tell off the top of my head. I was thinking still thinking about the institutions you mentioned. Sorry, but it. So you mentioned the PTOs, whether they should be having a more active role, and I do recall there was a proposal. I don't know what happened to that. But in Japan, that you could basically unilaterally start arbitrate. I think it never made it beyond the proposal stage. That implementers could unilaterally start an arbitration about setting a FRAND rate for portfolios, and I think there was in almost, I wouldn't say industry-wide skepticism, but there was a lot of voices that were skeptic about that, and I'm not sure. And we've heard about like essentiality checks by the PTO, and I'm also not quite sure whether your run-of-the-mill patent examiner really has the skill to make an infringement analysis in the end of the day, right? Because that's what it is. So That leaves the standard setting or standard defining organizations, and I think that generally speaking, it would be preferable if there would be ADR mechanisms in those present. I don't know that there are that many, and I think if the patent proprietors would have an appetite for that, they could do it, right? They, in the end of the day, are the standard definers, the standards setting organizations. So if there would really be an industry-wide appetite for it, I could see how this would be implemented. At the moment, I only know of one. I think there's probably more, but I know of one standard defining organization, which is the OSPT, which concerns itself with with transportation and payment methods and trying to come up with standards, and I think they've done so. And they have a binding expert determination for the question as to whether IPR is essential to the standard or not. And they also, I think, the Articles of Association also do contemplate a binding arbitration when it comes to disputes between the members of that organization. So, but that's I think it's rather rare, but I mean, that could be something that would certainly get the numbers higher for those kind of cases, right? Because you would be bound as a member of that organization. But
I mean, at the moment there are many ideas, flying around. Like some in the EU Commission seem to prefer some sort of agency's solution to which an ADR mechanism could be attached, and there there are pools out there, and there's talk about having larger pools which control for quality and which do their own ADR and such things. As if you are allowed to tell, would you see any kind of bandwagon of that sort? Which Google would be willing to follow, or is it just you watch the scenery, or is it you say, well, the existing ADR mechanisms and institutions are not that great, but let's see what better comes, or is there anything concrete that you would see on the horizon as being most interesting in that sense?
That's very hard to answer. I mean, if we were a member of such an organization, right, that would have those rules, that would have those mechanisms, of course we would use them.
Yeah.
So I think that makes, but that would require us being member in those organizations. And as I said, there's not so many.
Yeah.
I personally think it could be an interesting vehicle to have a neutral intermediary or agency that would come up with a standardized way of dealing with those disputes. It's similar. We just spoke in the break with Judge Zigan about this, and he mentioned that he drew the comparison to copyright licensing, and I think that could be indeed it could be something to explore. I think it's just it's pretty premature. And again, I never crossed my mind till the break before we started.
So. I will ask Clemens about his views on collecting societies for FRAND royalties in a moment, maybe. But Juliane, you had a point before, yeah?
Yeah, only because one of the things or one of the ideas and one of the buzzwords was this carve-out of specific questions, whether or not this could go to an own institution. And I know from all the discussions, also from other conferences, and also in the Commission's view, it's something like that if somebody could do an essentiality check of a patent, that would be very useful, because then it could be used everywhere. But you may remember that the Japanese Patent Office has this hentai introduced. And I remember from the last conference, the representative made a very interesting presentation on it, and then somebody from the audience asked how many cases they had, and he said 0. That means, for me, it means theoretically we are talking about great things, but it needs to be really, somebody needs to trust it in a way that the industry is accepting it and saying, okay, that's fine. But how to get this far, maybe somebody goes in the lead and then everybody sees, oh yeah, that's a great way to go. And then everybody in a way is following. That's more like a personal thing. I think it's more like, we will see what happens, and but I think from an academic way of looking at the things, it's very useful to have that. But I don't know whether or not it really will survive in the open world. And as we also saw before in the other panel, we are talking about completely different industries in a way, dealing with the very same thing. We are here now specific type of industry as a telecommunication industry, but yes, we will have a lot of other players. You may bring this at the next, like SMEs and so on, which have completely different views and maybe also different needs, because to be honest, a big company can afford to have a big internal legal team dealing with litigation and arbitration, but an SME may don't have. And I think that's completely different. You cannot have one solution fitting to all.
Certainly, if we had car people on the panel or small spare part producers, we might have some other aspects, you know, being pronounced. I see that we are almost 12 minutes before the end of our session. I would like to reserve 10 minutes at least for Q&A. So I would propose to do a rather short last round on one or, if possible, 2 points that came up before and that I find very interesting, and on which I would love to have your views, namely relationship between arbitral awards and competition law. Do you really, once you have an arbitral award, is there really no guarantee, or should there be no guarantee that this isn't been overturned for violation of competition law? For example, when you try to enforce it under the New York Convention and you then consider a violation of EU competition law an ordre public violation. So that would be my first question. How do you see that relationship? And the second question, which you do not have to answer if there is no time or if you don't feel like, goes to confidentiality again, because I think this is really an interesting point, especially in the SEP FRAND area, where agencies are watching rather closely what is going on, and where, you know, important questions also for the 5G future are negotiated, whether we should be happy if everything is kind of covered by confidentiality, or whether we should force parties to make everything open and thereby potentially undermine, you know, one of the core advantages of ADR, or how we should proceed in my last chance to say that, according to your very personal non-company views, how we should proceed in these two fields. Clemens, maybe? Or?
Yeah, if I can start on the first one, the award versus competition law. I think it is a well-established principles that there is, let's say, no appeal to arbitration awards. That's the reason why people agree on arbitration. They want to have it all in one go. On the other hand, it's also well established that let's say there must be kind of safety net for the, let's say, for some cases which went completely wrong, let's say it that way. So I think ordre public, also with regard to competition law as such, is a good thing. But on the other hand, I think it must be applied, let's say, carefully. So if every award would be lifted in the end only because the state court thinks no, 0.01 is too high, it should have been 0.008, something that is certainly not what it should be about. It should really be reserved for, let's say, fundamental errors. Second point, confidentiality. Claudia pointed it out very nicely. It is, of course, a conflict. On the one hand, I was also saying we want more knowledge, more transparency. On the other hand, we want transparency on the other parties' awards. Our own awards, of course, everything is strictly confidential. That is, of course, a challenge. And so therefore, state courts, for example, publish judgments where they blacken very confidential information. And sometimes when I read state court judgments, I'm not so interested of the numbers. Does company A sell 500 or 600,000 units? I'm more interested in the, let's say, legal principles, how the court applies the law. So therefore, I think it should be possible to make fair compromises. So publishing some more awards and giving the parties the possibility to redact what they really consider to be confidential, that might be a good way forward, on my own behalf.
Yeah, I completely agree with Clemens on the competition law issues, that of course the fundamentals of the competition law should be used also in ADR proceedings. But the question is how far this goes, and I don't really have a full answer on that. I only saw that of course, when I started as a litigator in patent law, I simply had to deal with patents, and now I have much more to deal with competition law than with patents. That means, yes, of course, there are things we need to learn and need to consider, and it could be that even also how the arbitrators are chosen. Maybe then somebody has this background and brings it in, and that could be useful too. On transparency, as I said, I'm also in a way, there are different hearts in one body, because I think on both sides you have good arguments to say, like, okay, more transparency is good, or less transparency is also fine. It depends, because if the transparency goes so far that nobody is using ADR proceedings anymore, then that is also not the way it should go. On the other hand, I completely agree that, especially, and that's my personal view, and I'm saying it now really, that methods how to calculate and so on, which don't go into really detail, are very useful to know, because every court is using also the methods of other courts, and why should not the very same principle apply to this? And in a way, it will also make ADR more attractive, because, as I said before, one of the things is, if you are not really having done millions of cases, you maybe don't know what's happening, and therefore you don't know whether or not it's good or not. And if you have some information published, it should be quite useful. The question is, where is the level, and where is how much should be published and transparent.
Right. Because transparency is, in fact, I think, boon and bane of FRAND ADR, right? Because, like, on the one hand, it's great to have, but, like, if there's no decisions published, if I can't advise my client as to how likely a tribunal would maybe calculate a certain licensing rate for a standard, I can't recommend it to my client, and I think no one can. And I think that's why, if there would be more transparency, I think it would really help the whole ADR process to be more widely accepted and more widely, I think it's generally accepted, but more widely used. And I think I really do like to read the parts of the judgment where they talk about the numbers, because that's what it boils down to at the end of the day. And so if there isn't any precedent or persuasive precedent, right, it's very hard to advise your client. And so that's maybe also would just change, I think, the acceptance of ADR in the SET world as such.
In competition law?
I think, in the interest of time, yes.
Yes.
So,
Okay.
but like, not too much. So.
Okay. Very good. Very good. So consensus on the panel, and hopefully vivid opposing views from the audience. So that's Q&A now.
So yeah, so Adrian House-Knock here. It's kind of a question and a comment. So I'll start with the question, but do you think that arbitration institutes could be a little bit more inventive? So far, I see some arbitration institutes, they've got some interest in FRAND, but frankly speaking, they are looking at it from the perspective of how arbitration has been done before. Arbitration agreements, is it the right kind? Obviously, that's important, but the key aspect and the key issue here is how do you incentivize both parties to agree to arbitrate under a particular institution's rules? And I think, given what's been said here by both Ralph, Clements, and many others, and also a lot of thinking behind the scenes by companies involved in this, there's a lot to be said about, well, should we be looking a little bit earlier in the negotiation phase from an institution's perspective, and also after? So earlier being the case of, well, how do you incentivize parties to agree to arbitrate? Should certain protections be given to the potential licensee vis-a-vis potential court proceedings, certain time periods associated with negotiations? I mean, obviously this depends massively on the value of a particular case and the circumstances of it. But it'd be nice to see a little bit of invention and maybe a little bit of difference between arbitration institutes as a sort of selling point. And transparency is another one. I mean, it seems to me a little bit difficult about how you do that outside a particular institute. I mean, obviously it could be publicly disclosed, but then it wouldn't an incentive be in its own right that it's not publicly disclosed, but at least, for example, the arbitrators and possible mediators of that institute have access to the previous decisions, so they at least know what the rates were and the full understanding of the decision. So I think there's a lot of potential for invention here and a lot of potential for new ideas, but I'm not really seeing them, at least from the Arbitration Institute, but just wondering what your thoughts were.
Yeah. Should we collect a bit first? I think there was another question before that. Sorry.
Thank you, Atif Bhati from Linklaters. Thank you for your insights. So I take away ADR is not used that much in FRAND SEP cases because we have, well, good jurisdictions with good courts and judges and with a lot of predictability. But I just would like to get your view if you think even if you would like to go to ADR, would it not be very hard also to convince internally the senior management of companies because they themselves have not experience? And I'm just asking this because one of our clients, she did a mediation, but she told me that it was very, very hard to convince actually the senior management, and she could only do it because not very much was at stake at this small case. But then the outcome was actually quite good.
So maybe one more question, and then we do a round of answers, and then we follow up with the questions.
Thank you. Benjamin Reetz of Kata Augenstein. Just wondering about the substantive law applicable to a case that goes to arbitration. Is that an issue that you have come across as an actual problem when you're in the process of setting up an arbitration? Because obviously there are many obstacles on the road, getting the other party to the table, but it seems to be an important decision that informs many other parameters of the arbitration, for example, the choice in arbitrators. And I'm just wondering if the substantive law applicable to a particular case is, I don't know, on your minds when you think about arbitration, or whether that is not really a major issue. Thank you.
Who wants to? I mean, I can take a stab at the last question. Maybe I think it's actually very vital to decide on the applicable law, and that's also again comes to mind when you advise your internal client. Like how do you which law to choose? I mean, it informs a lot of things, but like which law do you want to pick? As long as case law is existing, but it's maybe not fully settled. So I think it's important, and the more settled case law there is in a certain jurisdiction, the easier it gets. The same is true also, I think, goes to the transparency aspect. The more that's available, not only to the institutions and the arbitrators, but also to the parties, the easier it will be to inform yourself about like how this could go and to make a recommendation as to use ADR for your FRAND dispute or not. And I think as long as it's going to be incredibly hard. If there's no settled case law, just like when it comes to just applicable law, I think it's very hard. But also when there's no awards being published, it's incredibly hard to give advice. It's
yeah.
Ladies first.
Ladies first.
Thanks. Yeah, I'm a bit jumping to the second question from Atif regarding whether or not that could be a problem that the people deciding on specific matters don't have the experience on it. I completely agree with you, because the thing is. And this is somehow also a bit related to your question regarding jurisdictions. In China, arbitration is very, very raw. That's something they are not really used to use. There are systems to use it, but nobody really using it. But on the other hand, mediation is something which is very widely accepted and is also some part of the Chinese cultural. I think it's also even from other Asian countries. This is something, having a third neutral party helping you to find a settlement is something which is very in deep since thousands of years there in this culture. And therefore, this is something they are more used to it, and of course are also using it. But if something is in a way new and strange, and they don't know the outcome because there's no really case law available, it's very hard internally to say like, okay, that could be a good thing. Okay, it could be very expensive, as we know from other cases, but yeah, let's see what's happening. This could be a problem, but we will solve it.
Yeah, maybe let me also just come to the second question from Atif. I think our management, they are mostly not lawyers, but business people. And business people don't like litigation at all. It's for them just a cost center and just uncertainty, delay, blah, blah, blah. So this means they don't like it. And if I tell them the alternatives are going to court, and they ask me, so when is it settled? I just say, don't know. Ideally, just by filing the complaint, the other side comes back to the table. Sometimes before judgment, sometimes after judgment, sometimes they go the entire way up to Peter, and then it can take 6 years, 7 years, 8 years, and that is something they hate to hear. So therefore, if I can say arbitration, we will get the award within 12 months, 18 months, whatever. That is an incentive to accept it. So they might like it. For the other side, the user side, the defendant side, we hear a lot of complaints about injunctions in patent law. In some countries it's discretionary, in other countries it's not so discretionary. There's a lot of arguments at the moment, especially in Germany. Let's not go into that. But all these people who complain about the threat of an injunction, yeah, why don't they accept ADR? There's no injunction threat. At the end of the day, the tribunal will say whether the patent is used. If it is used, what is the price for the license, and that's it. So here we go. So therefore, I think there are good incentives for both sides to accept a ADR, and we as in-house lawyers, we have the job to convince our management.
Okay, I fear, although I know there are more questions in the audience, I fear in the interest of time we have to make a cut, go into the refreshment break, and refer all questions to bilateral discussions for the moment. But we will have another Q&A after the judges panel. So thank you to all the panelists. It was great. Thank you very much.